Welcome, everybody. Welcome to our event today. Our event, which is called Preventing and Punishing the Steps to Genocide on the eve of Holocaust Memorial Day. I am Mariana Goetz. I am the founding director of Rights for Peace. Rights for Peace is a relatively new nonprofit whose mission is to use human rights education, monitoring, and legal advocacy towards prevention of mass atrocity crimes. And at its center is an approach that is supportive of a collaboration with local actors in fragile states, investing resources at the front lines where they are most needed and absent. I would like to welcome all the participants. I'd like to welcome our panelists, and in particular, our esteemed chair, Judge Silvia Fernandez de Gurmendi. Silvia is chair also of GAAMAC. GAAMAC is the Global Action Against Mass Atrocity Crimes, which is supporting this event today. She is also president of the Assembly of States Parties of the International Criminal Court, special representative of Argentina to the International Holocaust Remembrance Alliance, and president of the Latin American Society of International Law. Silvia is a long-standing diplomat and international lawyer from Argentina who has served also as an appeals judge at the International Criminal Court from 2010 to 2018, and was president of the International Criminal Court for the last 3 years of her mandate. This event aims to spur discussion around improving our human rights tools for preventing mass atrocity crimes by looking at the violations that constitute the steps of genocide through a prism of hate. It's also an event that launches our guide, which is Hate Crimes to Violations in International Law, which we hope will support the work of human rights practitioners and activists. And now, without any further ado, I will hand over to Silvia, who will chair and also has some opening remarks. Thank you.
Thank you, Mariana. Welcome to everyone online, and to welcome and good morning, good afternoon to all these esteemed panelists. I am Silvia Fernandez. I'm the chair of the Global Action Against Mass Atrocity Crimes, GAAMAC. GAAMAC is a global and inclusive network of states, civil society, and academic institutions that aim to support states in establishing national architectures and policies for the early and permanent prevention of atrocities. To this effect, GAAMAC works with others. It has 18 partners, civil society and states, and we are very pleased to count Rights for Peace as one of our partners and to support them for this event. Rights for Peace is a relatively new non-profit organization, as Mariana has just said, whose mission is to use human rights education, monitoring, and legal advocacy towards the prevention of mass atrocity crimes. Prevention can and should be dealt with from multiple perspectives and fronts. For most of my professional career, I have been involved in prevention from the perspective of international criminal justice in particular, including, as it has been said, as judge and president of the ICC. And I have to say there has been an impressive development in international criminal justice in the last 3 decades, on the understanding that bringing the perpetrators before justice is essential for the prevention of future atrocities and for the healing of affected societies. Now, however, without prejudice to such justice initiatives, prevention also requires to identify and address the underlying causes of atrocities and the precursors of violence with the appropriate policies and mechanisms. That is why I joined early on in efforts to create the GAAMAC, and I'm now honored to lead GAAMAC in its prevention efforts. Tomorrow, as it has been recalled, we are commemorating the Holocaust. We are commemorating and honor the victims of the Holocaust. It is also a day to remember that despite the international community committing to never again allow atrocities after the Second World War, genocide have continued and continue to take place across the world. Mass atrocities do not simply happen overnight. We have learned that they are the result of long processes that can and must be prevented. And as I said, the GAAMAC seeks to help states to understand and address early on and on a permanent basis these causes and these precursors of violence before they escalate into mass atrocities. So we know that hate speech and incitement are well-known precursors to violence. The global rise of hate speech and discrimination that we are witnessing now, it has amplified by social media and the COVID-19, and is a strong reminder that no society is immune. So this is why the launch of Rights for Peace Guide to Hate Violations is very, very timely. The guide brings together the various provisions and mechanisms relating to hate speech, human rights violations, and international crimes into a single volume in order to support the work of human rights practitioners and activists. So on the occasion of this launch, today's discussion is aimed at advancing our understanding on the implementation of international human rights standards and the prevention of identity-based violence with regards to hate crime in international law. We will first have a conversation with our distinguished panelists, and you will then have the time to ask questions during the Q&A segment. We encourage you to use the chat to share any links to your work or insights you may have. I will now introduce each panelist in turn, asking them direct questions that I would like them to address to help us in this reflection. Now I will start with Mariana. Mariana Goetz is the founder of Rights for Peace. She's a human rights practitioner with over 20 years experience in post-conflict justice, including at the Rwanda Tribunal and Special Court for Sierra Leone, where she was a legal advisor. More recently, she was head of programs at Aegis Trust, and prior to that, deputy director of Redress, where she had been its post-conflict justice advisor, working on transitional justice cases and projects with affected communities in DRC, Northern Uganda, Kenya, Central African Republic. So she has an amazing and impressive experience. So maybe she could address this opening question. Tell us a little bit about the guide to hate violations. What gaps it aims to fill, if any?
Indeed, if any. Thank you, Sylvia. Well, the guide started off as a training tool, in fact, and is very much linked to the raison d'etre of Rights for Peace, which is looking at mass atrocity prevention from a human rights perspective. And really, our knowledge, as you put it, also well put by Sherry Rosenberg, that genocide is a process and not an event, and that the Holocaust didn't start with the gas chambers, it started with hate speech. This really informed our thinking of this idea of a process and a progression of violations that leads to the ultimate hate crime of genocide. And it's also interesting now that there is so much considerable research about these processes through genocide studies, which are now widely taught in many universities, how these hate crime narratives, or these hate narratives permeate societies and ultimately can fuel mass violence. So, I mean, there are many descriptions of these stages. We have Dr. Gregory Stanton, I'm sure many of you have seen, the 10 Steps to Genocide. Professor Erwin Staub takes a much more sociological perspective, very interesting research on what he calls a continuum of violence, which also looks at the stages that lead to increased tolerance for these violations. And then there is also the Anti-Defamation League that has a pyramid of hate that I'm sure a number of you have seen, though I'm going to share it on my screen just now, which, as you may know, starts at the bottom of the pyramid with this idea of biased attitudes. Then we move on to acts of bias, discrimination, bias-motivated violence, increasingly organized bias-motivated violence, and ultimately genocide at the very top of the pyramid is the ultimate hate crime. So having looked at this at this pyramid and at these different stages and learning more about them, we felt that it was useful to look at the steps of these violations that lead to genocide. The Genocide Convention tells us that states have an obligation to prevent and punish, but we feel that actually a lot more resources go into dealing with the consequences of mass violence, and that includes punishment rather than on prevention. And at the same time, the current Secretary General, Antonio Guterres, has said that we need new approaches and that prevention is not just a priority, it is the priority. So there are some evolutions, and the UN hate speech action plan produced by the Special Advisor on the Prevention of Genocide is an example of these advances in our thinking about preventing and punishing these steps. But there's also a lot we can learn from domestic hate crime prevention. If we use this prism of hate crime, we can see that actually criminology at a domestic level has been around for a long time, and the evolution of the concept of hate crime has really advanced at the domestic level, the work in prevention. Creating dedicated hate crime legislation helps focus policy and mobilize resources. It helps interventions to be designed to raise awareness and promote tolerance in society. There are interventions to reduce repeat offending, etc. All these kinds of things in terms of dedicated police training, etc. at the national level can give us a really rich basis to think about how we look at prevention of international crimes. And in fact, the 57 OSCE countries regularly provide information and statistics on their own hate crime policing and reporting, which is centrally published at the OSCE. However, at the international level, when we think of conflict prevention and early warning systems, we track the increase of violence, but we don't necessarily track the motivation, this bait, this bias intent. So we miss perhaps a really key, pattern and the rise of violence. And in terms of the international human rights framework, again, we do not really consider this bias motivation other than for genocide itself. But by then, we've reached all the steps. So we know that actually these bias motivations exist in human rights law. I mean, a lot of human rights conventions actually are, at the very heart of them is the prevention of discrimination. So they're existing all over, but they're fragmented, and across different provisions, we find different elements that relate to this bias intent that might be able to help us see this progression through the prism of hate. So here I wanted to share with you another little screen, which is in our guide. And effectively, it's the same pyramid of hate, but we've superimposed onto it the human rights violations. On the left side, you can see all the provisions that include a bias intent element. And then on the other side, all the mechanisms that relate to those provisions. So we have mechanisms of the Human Rights Committee in relation to ICCPR and the prevention of incitement to discrimination and violence under Article 20, (2) of ICCPR. There are provisions under CEDAW. There are provisions in the Torture Convention. There is the concept of apartheid, etc. So they move up the pyramid and progress from human rights violations into international crimes. So essentially, the guide is all it's doing really is going through all these different provisions and putting them all under one roof to help with our work at the field level in terms of trying to document and visualize these violations from this point of view. From a field perspective, in a way, it has made us think about how well the human rights system works in terms of mass atrocity prevention, from a mass atrocity prevention point of view. And we noticed that really a lot of the reporting that goes on around human rights and also international crimes are just simply reported as sexual violence, rape, torture, arbitrary arrests, etc. They're not infused with the element of the intent as to why. It's the same way that we have it in a domestic level relating to hate crimes, which basically are any crime, could be even graffiti or assault, which is accompanied by that bias intent. And we noticed that when we report and monitor human rights violations and international crimes in the field, whether it's by local human rights defenders, whether it's by international NGOs, whether it's in cases that are brought before UN bodies, or whether it's in international investigations and prosecutions, we don't really look at that aspect. We don't really look at the bias intent as it evolves going up the pyramid. And so we're just questioning whether, if thinking about human rights violations and international crimes through a prism of hate can actually help us be more effective. Can it help us in designing better preventative interventions? Can it help us in monitoring and reporting hate-based violations and crimes the way in which the OSCE does? Can it help us in improving scrutiny and early warning systems? And can we also improve best practice standards in policing and reporting hate crime internationally? So those are just some of the questions that we wanted to share and raise with others. And we hope that today's discussion will be a first step in looking at those. Thank you very much.
Thank you very much, Mariana, for this very useful introduction to our panel today, with recalling what is already there and what is not yet sufficiently taken into account, or which is indeed this bias intent, and that you have well explained that may indeed help in the reporting mechanisms, that it could really make a difference in the particular context. So thank you for this. And maybe we could now move to our second panelist. This is Dr. Sejal Parmar, who is a lecturer at the School of Law and a fellow at the Center for Freedom of the Media at the University of Sheffield. She's also a visiting professor at the Central European University in Vienna. Dr. Parmar previously worked as senior advisor to the Organization for Security and Cooperation in Europe, OSCE, as representative on freedom of the media and as a senior legal officer of Article 19. During 2020, she worked as a consultant for the UN Office on Genocide Prevention and the Responsibility to Protect, to develop a detailed guidance on the implementation of the UN strategy and action plan on hate speech. So my question to Dr. Parmar would be that we would be interested to hear your thoughts on lessons learned on the implementation of the action plan. Can any of these lessons be helpful for the next steps on preventing the steps to genocide that have been recalled by Mariana? Thank you very much, Dr. Parmar. You have the floor.
Thank you very much, Judge Fernandez, and thanks to Rights for Peace and GAAMAC for inviting me on this very esteemed panel. So good afternoon, everyone. In addressing that question posed to me, what I'll do is first to really address what the UN strategy and plan of action is, and then to show its value in terms of addressing hate crimes, which are the subject of the report which is being launched today. So the UN Strategy and Plan of Action on Hate Speech was launched in June 2019, and it's the first system-wide initiative designed to tackle hate speech as such. It has a definition of hate speech, which is any kind of communication in speech, writing, or behavior that attacks or uses pejorative or discriminatory language with reference to a person or a group on the basis of who they are. In other words, based on their religion, ethnicity, nationality, race, color, descent, gender, or other identity factor. Now, this is not a legal definition, and it's broader than the notion of incitement to hostility, discrimination, or violence, which is prohibited under international human rights law. But the definition in the strategy does provide a single unified framework for how the United Nations system should address hate speech globally. The strategy and plan of action, but also the detailed guidance on which I worked as the consultant, was developed in cooperation with 14 UN entities, as well as field presences. The point of the strategy is really to task the UN itself with addressing the root causes and drivers of hate speech, and also enabling effective responses to its impact upon societies in collaboration with states and other actors. So the document which was launched in September, which really fleshes out, this is the document here, the detailed guidance on the strategy and plan of action, that is intended to provide detailed advice and direction on how the strategy should be effectively implemented on the ground by UN field presences who work on the front lines of the system. So the detailed guidance translates each of the strategy's 13 commitments into concrete actions to be taken by those field presences in both mission and non-mission settings, including resident coordinators, humanitarian coordinators, special representatives, special envoys, personal envoys, and special coordinators in political and peacekeeping missions, as well as country teams and all UN staff. So this detailed guidance has a very significant impact for how the UN addresses what is really at the bottom level or just one level above prejudiced attitudes in the pyramid of hate speech, which Mariana outlined. So in fleshing out how this strategy should be implemented, the detailed guidance does give a clear, common and concrete approach to addressing and countering hate speech. And one which as I suggested, is system-wide. The emphasis of the detailed guidance is upon states as the primary duty bearers under the international legal framework. The detailed guidance indicates that they do have the primary responsibility to address and counter hate speech. And the detailed guidance essentially provides a framework for how the UN, working with others, including civil society organizations, media outlets, tech companies, social media platforms, and so forth, can support and complement states in their efforts to address and counter hate speech. I won't drill down into the detailed guidance, but you should know that it unpacks the general 13 commitments contained in the strategy and plan of action into 27 actions encompassing 107 recommendations. So I encourage you to look at that as to see how particular parts of the UN system on the ground should address hate speech. So how does this strategy and plan of action and the detailed guidance relate to the subject of this afternoon's discussion on the steps leading to atrocity crimes? So first and foremost, as was already indicated, the motivation of the detailed guidance is very much in line with the current approach of the Secretary General, which is to recognize that hate speech is a common precursor to atrocity crimes, including genocide, in many situations from Rwanda to Bosnia to Cambodia, as the Secretary General indicated in launching the strategy. There are, of course, more recent examples of atrocity crimes, including the dehumanization and the genocide against the Rwanda, which was the result of, Rohingya, excuse me, which was driven by social media. And the guidance does consciously reflect the lessons learned from those past experiences, including Myanmar, but also Sri Lanka, and specifically the lessons drawn from the Rosenthal and Petrie reports concerning the involvement of the UN in Myanmar and Sri Lanka, as well as their human rights upfront agenda. The second reason why there is a connection is that the detailed guidance does offer a comprehensive approach in clearly identifying key actors on the ground, in adopting a whole of system approach to addressing crimes motivated by hatred. And it speaks to very specific actors, which encompass resident coordinators and the heads of agencies in UN country teams, including in their role as humanitarian coordinators, special representatives, special envoys, personal envoys, the representatives and special coordinators in political and peacekeeping missions. In addition, the regional offices of entities of the UN system, such as the UN Human Rights Office or the UN Development Programme, UNESCO, and other entities are also addressed. The third reason why I think it is useful, this detailed guidance, is because it presents a disaggregated approach in terms of the roles of these particular actors, offering concrete steps for action and indicating their relationships with non-state actors, including the media, civil society, and tech companies. So, for example, the general commitment concerning technology offered in the strategy and plan of action is fleshed out through 3 actions, actions 16 to 18 in the detailed guidance, which essentially shows how UN actors on the ground should behave and what activities they should be involved in, which include the enhancement of the skills, expertise, and resilience of key staff on the ground, the engagement that they should have with private actors, which includes the promotion of international human rights law through those engagements. And also action point 18 concerns the flagging of content by UN actors on the ground, content that constitutes incitement to tech companies. So that's sort of a couple of the examples concerning how the detailed guidance really offers some practical guidance for various UN actors on the ground in supporting the comprehensive approach to hate speech that I think the UN strategy and plan of action is aiming towards. So I'll leave my comments there for now and look forward to the discussion with fellow panelists and with participants. Thank you very much.
Thank you very much, Dr. Palmer, for this very clear overview on the strategy and plan of action on hate speech of the UN. This is extremely useful, as you said, because it provides both a single unified framework for action, but also very concrete recommendations for all relevant actors to take in this regard. And this does take us to the next panel with the panelists who is going to be dealing with the roles and responsibilities of some of these actors, in this case of religious leaders, in addressing incitement to hatred and violence. I would now then give the floor to Michael Wiener. Michael Wiener has been working since 2006 at the Office of the United Nations High Commissioner for Human Rights. He was one of the experts who participated in Article 19's consultations that drafted the Camden Principles on freedom of expression and equality. He was also part of the core team organizing 5 OHCHR expert workshops that led to the adoption of the Rabat Plan of Action on the prohibition of advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. Since 2017, he has been working on the design and implementation of the Beirut Declaration and its 18 commitments on faith for rights. So my question to you would be to know to what extent human rights treaty bodies and special procedures mandates in Geneva already take a hate-based perspective and how they are engaging with faith actors to address incitement of hatred and violence. You have the floor.
Thank you very much for the kind invitation and also for this pertinent question. And many outputs of treaty bodies and special rapporteurs are already outlined in the hate crime manual by Rights for Peace, as Mariana explained at the outset. But I can zoom in into some recent examples of such hate-based perspective by UN human rights mechanisms. And perhaps just to start upfront with treaty bodies. These are the independent experts mandated to monitor state parties' compliance with their treaty obligations. And here the Committee on the Elimination of Racial Discrimination has been engaged by hate speech targeting persons belonging to certain ethnic groups who profess or practice a religion different from the majority, including expressions of Islamophobia, anti-Semitism, and other similar manifestations of hatred, as well as extreme manifestations of hatred such as incitement to genocide and to terrorism. This is also directly mentioned in a general recommendation on racist hate speech that the committee adopted already in 2013, so already almost 8 years ago. And there it also zoomed into a very important question, meaning the qualification: when is the threshold of incitement as an offense punishable by law reached? So this threshold question, which also Sejal was mentioning earlier on, is really key. And here the committee uses the Rabat Plan of Action, which is also part and parcel of the manual and also of the hate speech strategy and plan of action. And here the committee highlights contextual factors that should be taken into account: content, form of the speech, economic, social, political climate, status of the speaker, reach of the speech, objectives of the speech, and so on. So I think this is a very useful point and also guide for anyone who's looking into hate speech cases, to not inadvertently shoot down freedom of expression and only basically address those cases which reach the threshold of incitement to hatred. The Human Rights Committee, another treaty body, which is looking into the International Covenant on Civil and Political Rights, has also issued several related general comments, for example, on freedom of expression, and also most recently, just last July, on the right to peaceful assembly. Here, the committee also clearly stated that peaceful assemblies may not be used for propaganda for war or for advocacy of national, racial, religious hatred that constitutes incitement to discrimination, hostility, or violence. And that's, as Mariana mentioned, that's basically Article 20 of the International Covenant. So participation in assemblies whose dominant message falls within the scope of this article must be addressed in conformity with all the requirements for restrictions under freedom of expression and peaceful assembly. The committee also specifically refers to the threshold test under the Rabat Plan of Action and the Beirut Declaration on Faithful Rights. And I think here that's an interesting collaborative effort where the treaty bodies from the United Nations side, jointly with special rapporteurs, but also with civil society, both secular and faith-based, and academia, joined forces and really came up with specific guidance on the threshold. If we now just move quickly to special procedures and their recent pronouncements, an increasing number of communications to states is also taking an explicit hate-based analysis. And if we just look into examples from the last couple of months, I can point to, for example, 3 specific communications, which are also all available on the website of the Office of the High Commissioner for Human Rights. So the one case was on hate speech and violent attacks and harassment of peaceful protesters, which were disproportionately targeting Muslim religious minorities. Another case referred to hate speech against LGBT persons by religious leaders and public officials. So here you have basically different perpetrators. And then the third case, again, from just half a year ago, arrests under domestic hate speech and disinformation legislation, targeting journalists for posts related to government response to the COVID-19 pandemic, which they had published on social media. So I think these 3 cases can also nicely show the dilemmas and the challenges involved, which is also put in a very poignant form in the Rabat Plan of Action it's basically two sides of the coin. We have two problems we are facing. So many perpetrators of incidents which indeed reach the threshold of incitement are not prosecuted and punished. So this is the one side of the coin. And then on the other side, you have members of minorities, or basically journalists, human rights defenders, who are persecuted through the abuse of vague domestic legislation, jurisprudence, and policies on incitement. And I think the three examples that I just gave clearly show both the under-targeting of the real cases and the non-prosecution, and at the same time, the targeting of human rights defenders and minorities. This is also taken up in the Beirut Declaration. There's a specific commitment by these faith-based actors to publicly denounce all instances of advocacy of hatred that incites violence, discrimination, hostility, including those that lead to atrocity crimes. If I can just give you a very concrete example and also methodology, which is a peer-to-peer methodology where we are really learning from the various actors through this Faith for Rights framework. And there, the storytelling is one key methodology of really getting the understanding and learning lessons and sharing basically what works and what doesn't work. So in the Faith for Rights toolkit, as I said, there's a specific example raised by the Special Rapporteur on Freedom of Religion or Belief after a mission that he did to Sierra Leone. And he referred to a case where a Christian woman claimed to have a dream where she saw Muammar Gaddafi, and she basically called a particular mosque in Sierra Leone, which had been sponsored by Gaddafi, to be destroyed and replaced with a church. And this was a case that was raised by various interlocutors to the Special Rapporteur, because it was a success story, since the Christian churches in Sierra Leone and then also the Interreligious Council briefly and immediately stood up and said, we need to go against such a hate speech and act together to defend also the country's religious harmony. And this ultimately avoided any flaring up of hostility, of violence. And then also the United Council of Imams explicitly praised these churches for the quick and clear response. So I think this is an example where you can see how religious leaders can really have a very positive impact on the ground by immediately standing up and also abiding by their specific responsibilities under the Rabat Plan of Action and Beirut Declaration. Perhaps just to briefly also link this to something which Sejal had alluded to, in the context of the Plan of Action on hate speech, there's also a specific reference not only to the Rabat Plan of Action, but also the Plan of Action for religious leaders and actors to prevent and counter incitement to violence that could lead to atrocity crimes. And there, the Special Advisor on Prevention of Genocide had also organized several meetings in Bangladesh, in South Asia. And I think there you can really see how religious education can help to uphold the concepts of pluralism, respect of diversity, and inclusive citizenship. The last point I just wanted to briefly mention, because it also links to an ongoing discussion at the level of the Human Rights Council in Geneva. There will be, in just 2 weeks' time, an intersessional meeting of the Human Rights Council on the prevention of genocide, with a view to sharing good practices, achievements, challenges, and lessons learned. And this is really looking into the national capacities, promoting states' participation at regional and sub-regional levels, and strengthening early warning and prevention mechanisms within the United Nations. And I'll put just in the chat box the link for anyone who's interested in attending this intersessional meeting on the 10th of February. Thanks.
Thank you very much, Mr. Wiener, for this very interesting picture of the challenges that and dilemmas that we need to face when we are confronted with the problem of hate speech. The issue of the threshold, and you all very well mentioned this, the two coins of the problem with under targeting or over targeting, because we do not maybe understand this unified framework, and a vague legislation and vague understandings may lead to heighten this problem. So thank you very much also for recalling the special role of certain actors and in particular religious leaders, that they can have a positive impact on addressing this problem. So maybe now we could turn to the next panelist that was going to be addressing the frameworks for minority rights and upstream prevention. I would like to introduce on this segment Mr. Karl Söderberg, who is Director of Policy and Communications of Minority Rights Group since 2009. He has previously worked for Amnesty International, carrying out numerous human rights monitoring trips in Afghanistan, as well as other countries, with a focus on human rights and armed conflict, as well as refugees and internally displaced issues. Prior to that, Karl worked for the UN UNHCR in Pakistan and Sudan, and Karl is responsible for overseeing MRG's UN advocacy, publications, and media work. So my question to you, Mr. Söderberg, would be, how effective are the existing mechanisms from a minority rights perspective? Would you give us examples of cases where they thought it was a mass killing near genocide and the issues in doing that prevention work?
Thank you very much, Sylvia, for the question and the introduction, and also to Rights for Peace and GAAMAC for organizing this very timely and urgent webinar. I really appreciate getting to be sitting alongside the other panelists, and I've really enjoyed listening to all of you. So I'm just going to say a few words about MRG's work. Minority Rights Group works towards supporting minority and indigenous activists in their contacts with numerous international mechanisms. And I should say also that I'll be focusing on the UN mechanisms during the course of my presentation, because that is the focus of my work and what I know best. And we will accompany representatives and assist them in preparing for their interventions, for instance, before the UN Forum on Minority Issues, but numerous other mechanisms as well. And I would say, in answer to the question initially, that the various UN mechanisms protecting minority and indigenous people's rights have, frankly, a relatively mixed track record. One thing I do want to emphasize is that I have a very positive impression in terms of how that there are numerous ways in which minority and indigenous representatives can bring issues to the attention of various UN mechanisms. Also, generally, UN staff and the various experts working for these various mechanisms are very open to receiving information, and I find them generally to be very supportive and serious in their endeavors. However, frankly, it feels as if the mechanisms have been designed without particular care having been given to ensure accessibility and transparency for victims, because after all, effectiveness also should be measured in terms of relevance. And rather, it feels to me, despite the fact that I've been working in and around the UN for over 30 years, that we're talking about an alphabet soup of treaty bodies, special rapporteurs, and so on, that makes sense to state delegations, UN staff, and those NGO staff, such as myself, plus academics, journalists who are used to navigating those corridors, but not necessarily to the victims themselves. And one thing I want to stress that I don't think is so apparent if you don't work alongside minority and indigenous representatives is how challenging the environment at the UN can be. We help roughly 20 or 30 minority activists speak at the Minority Forum every year. That forum has a 2 to 3 minute rule for speaking, although written submissions can be longer, and a thematic focus for each session. Now let's put ourselves in the shoes of a new person attending for the first time, someone representing a vulnerable community in some country. And this can be incredibly fraught. How to describe a complex, very threatening situation in 2 minutes? And besides, that thematic focus for each session, which is understandable, is being increasingly used by hostile states, calling points of order repeatedly to interrupt and intimidate civil society speakers. They'll be especially using that theme as an excuse to interrupt. I should say that the Indigenous Forum is a bit more open as it is longer, and so representatives will usually get a chance to speak more than once. But the Minorities Forum is particularly difficult because it is only for 2 days. Still, with the Indigenous Forum, the most notorious case I've seen in recent times was, I think, 3 years ago, when a Uyghur representative was barred by UN guards from re-entering the hall of the Indigenous Forum at the UN in New York after a coffee break following a complaint from the Chinese delegation. That delegate the representative of the Uyghur community wasn't even allowed to re-enter the hall to pick up his laptop. And indeed, the World Uyghur Congress has since struggled to get the necessary accreditation to attend subsequent sessions of the Indigenous Forum. And that practice of intimidation has increased dramatically in the past 6-7 years or so. And we at MRG have to count on some form of intimidation towards community members, either in the UN buildings or upon return, as something as par for this course. We're going to have to expect it every time we are accompanying community members to the United Nations. And this escalates even up to the level of detention, either prior to or after attendance. And we have one case currently, I don't want to name the country, of a person who was detained just as he was about to pick up his Swiss visa to attend the Minorities Forum in 2019. And sadly, the person remains in detention this day. And I should say the chair of the forum was very supportive, protesting from the podium. Special rapporteurs have issued statements. OHCHR have been following up very closely with us. But it really underscores the challenging environment it is for minority activists at the UN these days, and how we're having to prepare for that. Now, turning to the country level, I want to point to, for instance, the case of Myanmar and Gert Rosenthal's review of the UN presence in Myanmar, which was published in May 2019. And I'd highly recommend the listeners, the viewers, if you've not read it, please do so. And Rosenthal underscores the divergence of different UN entities in any one country, the tension between quiet diplomacy on the one hand and outspoken advocacy on the other. Those are the terms he uses in his report. And also how the silos between different units add to the discordancy. Now, from our experience, we also know of cases where minority and indigenous representatives find it difficult to reach UN staff in UN country offices. This may be because in practice there are gatekeepers, and those gatekeepers, the security guards, the receptionists, and so on, may well belong to majorities. And so members of minority communities may find it very difficult to get in touch with the UN staff in UN country offices. Another problem, of course, hindrance, is the state's role in granting or denying requests to visit. We have an imminent case right now, a terrible incident of 46 indigenous Batwa community members killed on the 14th of January in Ituri province in eastern DRC. We're supporting our partners on the ground by helping them contact a range of the various UN entities that you've already heard described, plus others. And we've understood that from the offices of two of the special rapporteurs that they have made a request to visit the DRC. But of course, it's up to the government to accept those requests or not. And so we are pressing the authorities to accept this pending visit request. There are other issues at the country level. For instance, now we are seeing more and more increasingly used legislation clamping down on funding, overseas funding towards human rights defenders. And that is used in order to limit the ability of human rights defenders to work at all, but also, of course, to work towards the United Nations. So I think, in other words, it is very mixed. And I'm sure that there are cases where prevention occurs. For instance, there are positive aspects. I've not touched upon the ability of minority and indigenous representatives to use these fora as a kind of marketplace for sharing experiences, developing solidarity between communities and across regions, and that must be beneficial. But ultimately, the UN is a tough place to work for minority representatives in order to present their concerns. And as long as that remains the case, I think that the effectiveness is limited.
Thank you very much, Carl, for this very vivid overview of the practical problems and challenges for prevention, going from accessibility of existing mechanisms to victims, the challenging environment for minority activists at the UN building, but also at the country level, also to recall the state roles and responsibilities in granting access to minority communities. So thank you very much for this. That provides us a good overview of what we are experiencing on the ground. And now I think it's time for the audience for a Q&A. We have 30 minutes for Q&A questions from the audience. I will open now this part of our segment. I will remind the audience to submit their questions via the Q&A function. And I would like to first invite Christy Edwards to take the floor. He is the Deputy Head of the Tolerance and Non-Discrimination Unit of the OSCE's Office for Democracy and Human Rights.
Thank you so much. Can you hear me now? Okay.
Thank you very much, Christy. Yes, you have the floor. Sorry, I couldn't hear.
Okay, great. Well, thank you all so much for your very inspiring remarks. It's wonderful to hear so much of the complementary nature of all of our work and from so many fantastic partners. So I guess first, maybe I'll just mention that to Mariana's point about work on the spectrum of violence between hate speech, hate crimes, and mass atrocities, we've also had a fantastic working relationship with the Office of the Special Advisor on Prevention of Genocide, and have been working on a series of workshops and trainings for the past 2 years or so, working with civil society organizations all across the OSCE region to help them and give them some training on being able to identify and address issues of hate speech and hate crime, hopefully before it ever rises to the level of mass atrocities in their communities. And then also to mention, I know Mariana also mentioned our work on hate crimes. As many of you may know, ODIHR's annual hate crime report is the largest data set of hate crimes in the world, and it gathers information from both official and civil society sources. So in our most recently released report, which just came out in November for the year 2019, there were a total of 39 OSCE participating states that reported hate crime, official hate crime data to ODIHR, including 25 states that provided figures classified by bias motivation. So this data set includes a record number of 3,207 statistical and 3,757 descriptive hate crime incidents reported by civil society. So that is just over 4,500 hate crime victims, which is a truly incredible number. And we know that that only is the tip of the iceberg. So maybe just looking at what are some lessons learned from the data that we're collecting across the OSCE region, and how that translates into sort of international opportunities. The report definitely shows that in many countries there are mechanisms in place to record and collect comprehensive data on hate crimes, but many still do not actually provide police and prosecutors with the tools and knowledge that they need to recognize, record, and effectively investigate hate crimes. And so this, of course, then prevents hate crime victims from the opportunities that they need to access very much needed support. Recording hate crimes, offering support to those who are affected is, of course, key to ensuring the security of individuals, their communities, and societies. And I think it's definitely important to note that, and I think some others mentioned, a comprehensive approach is truly necessary here. So not only do governments who bear the responsibility for addressing these issues at the national level, but civil society organizations, special services who work with victims, national points of contact on hate crime. I know our OSCE field offices work on these issues quite regularly. Other IGOs, academics, and many others are absolutely vital to these efforts at the local, national, regional, and international levels. So we've been working on a lot of these issues with many partners. GAAMAC, of course, we've done quite a bit of work with in the past. Obviously, our historical work with the Office of the Special Advisor, and we can regularly contribute to conversations with other IGOs, whether it's the Council of Europe, the European Commission, UNODC, looking at what are the legal definitions, what are the international definitions, what are some possible international frameworks. UNODC, of course, is working to hopefully gain consensus on these issues, and hopefully some of the lessons learned across the OSCE region, which is quite broad. It ranges from North America, all of Europe, and Central Asia, can also be brought to bear on the global level at this point as well. So I'll stop there. I know there's a lot of questions, so I'll turn it back over to the panel. And thanks so much for letting me share a bit about our work.
Thank you. Thank you very much, Christy, for this overview. And indeed, we have some very good questions from the audience. Actually, there is one that it relates to what Michael was telling us about this tension between hate speech and freedom of expression. And indeed, there is one question on how to address this issue, how to counter this perception that when you are addressing hate speech, you are affecting the freedom of expression. I don't know if you expand a little bit on this.
Yes, I'm happy to do that. And obviously, this is at the core of also of what Sejal, Mariana, and also to some extent Carl were talking about, really to define and to really identify those cases which are harmful, which really reach the threshold of incitement to hatred and violence. And there we have several instruments which need to be really, applied, and you need to have human analysis of it. I think a point that Sejal alluded in the beginning, the role of social media companies in particular when it comes to really moderating such content on their platforms. And I think here, many of these companies obviously have to rely on artificial intelligence to do the first screening. And some of these companies in their public reports, transparency reports, say that 95, 99% of their initial screening is done by algorithms. And I think here, what is really important to stress that after this initial screening of these posts, which obviously needs to be done initially by artificial intelligence, but then there always needs to be a human content moderator to look into this more concretely. This is also what, for example, the Special Rapporteur on Freedom of Expression highlighted in the report 2019 to the General Assembly, 20 to the General Assembly, precisely to look into the guidance and which standards should really be addressed by this. We have also had a very good interaction with the Office of the Special Advisor on Prevention of Genocide, precisely on this point in the context of the hate speech strategy, but also when it comes to really educating and engaging with students. And if you allow me just 1 minute to also react to Carl's very pertinent point on the situation and also the alphabet soup, as he nicely coined it, for minority representatives. And precisely for that reason, it's important to have a guide like Rights for Peace has just published. And from the Office of the High Commissioner for Human Rights, we are obviously trying also to facilitate this, notably through the Minority Fellowship Program and the Indigenous Peoples Fellowship Program, which precisely tries to empower these people from the grassroots, to have them acquaint for a month in Geneva and last time, for example, also in Strasbourg, with the various mechanisms so that they can use these mechanisms. And the last point, again, to reinforce the importance of addressing any cases of reprisals, which we are taking very seriously. There's also an annual follow-up and report by the Secretary General, and what Carl mentioned in terms of the situation on the forum and minority issues, that's obviously very much concerning. Thanks.
Thank you. Anybody else who want, anybody in the panelists that would like to take the floor on this again?
Sure. Thanks, Judge Fernandez. Yes, just in response to that first question about how is it possible to overcome the notion that countering hate speech is limiting free speech. I think it's important to focus in and emphasize these notions of hate speech and free speech. What do they really mean, in fact? You know, the idea of hate speech isn't something which is defined in international law as such. So the strategy and plan of action does give it a definition, but this is, as I emphasized, a non-legal definition. And it covers both lawful and unlawful types of hate speech. And unlawful types includes incitement to discrimination, hostility, and violence, and incitement to genocide. It also includes types of expression which may be permissibly restricted under Article 19 of the International Covenant on Civil and Political Rights, which is the provision on freedom of expression, the main provision on freedom of expression in international law. So it's important to remember that in international human rights law terms, but also in terms of the laws of domestic jurisdictions, freedom of expression or free speech isn't an absolute right. There are circumstances when it can, and in some cases should and must, be limited. So I think there is no contradiction between restricting some kinds of expression in some cases when it reaches that high threshold indicated in the Rabat Plan of Action, that some kinds of speech may be criminalized even. and the idea that there should be a freedom of expression. So there's no fundamental incompatibility there. That's what I wanted to say in relation to that question. And just to sort of come back to Carl's very astute and helpful critical observations about the interrelationship or interactions between civil society organizations working to promote the rights of persons belonging to minorities, and just to flag it up to participants, that last year's UN Forum on Minority Issues was precisely on the issue of hate speech and social media, and the upcoming report of the Special Rapporteur on Minority Issues will be on the same subject. So at the global level, apart from the report to the General Assembly of the UN Special Rapporteur on Freedom of Expression of October 2019, which was on social media and hate speech, and the Strategy and Plan of Action from June 2019, and now the detailed guidance from last September on the UN's approach, the Strategy and Plan of Action. There is an ongoing, I think, interest from the UN system on this particular subject of hate speech as part of this bigger pyramid of hate, which is the subject of this report. And it's not going to go away, obviously, with the current discussions and debates concerning the role and responsibility of social media platforms. So that's all I wanted to say for now, but I can come back to some other questions raised in connection with Ethiopia, for example.
Thank you very much. We have many very good questions from the audience, and there are several questions related to the impact of hate speech on migrants, including one that I see here, one from Lara Chiavarini from Fundación para la Democracia de Argentina, who would like to know, and this is very, very relevant today in the current context, what was the impact of the economic, social, sanitary crisis developed due to the pandemic in hate speech against migrants? Anybody who would like to address, any of the panelists could address this issue? Carl, a volunteer. Carl, please, you have the floor.
I will start on that, and I'm sure the other panelists will want to add to it. MRG issued a briefing on COVID and minority and indigenous people's rights in September, and we're planning to issue our annual report on the same topic later this year. And we were trying to, with the briefing, create an omnibus survey of the various impacts of the pandemic on minorities and indigenous peoples. But one of the specific issues that we highlighted already then in September, and we'll be going more deeply into it, is exactly what I think the person posing the question is alluding to, and that is how migrants were particularly targeted, stigmatized as having brought on or brought with them the coronavirus. And so we saw that in a range of countries, how hate speech occurrence was increasing and particularly targeting migrants. But I should say that it isn't limited, that pattern of blaming through hate speech, COVID on vulnerable groups is not limited to migrants alone. In various countries, it's also been minority communities, as well as indigenous peoples, that have similarly been accused of living in certain ways. A lot of stereotypes are used to explain that these communities are particularly causing or contributing to the spread of the virus. So this is really a pattern that we're seeing right across the world.
Thank you, Carl. Michael?
If I may just, yes, if I may just add to Carl's very pertinent points, the Special Rapporteur on Minority Issues, Fernande Varenne, already in March issued various public statements precisely pointing to the adverse effects and really the targeting of migrants, of minorities, of Asian descent. The Special Rapporteur on Freedom of Religion or Belief also specifically looked into the impact on minorities, on Jewish communities. And I think here you can see the scapegoating, how it really works to really always have one community to blame. And in the context of the Faithful Rights Toolkit, we have had lots of online engagements through webinars with really diverse participants. And one hypothetical case that we invented on a pandemic has been really very useful to discuss this with sometimes over 100 postgraduate students in one webinar. And this hypothetical case is basically using some elements of real case discrimination against minorities, against migrants, where political leaders, where religious leaders are really using or abusing the pandemic to target specific communities and for electoral gains. So I think such a discussion on cases, moot courts, which are also similarly looking into these things, can be very helpful to sensitize people to discuss and really to avoid making the same mistakes in different countries all over the world.
Thank you very much. We have lots of very, very good questions, and many of them relate actually on, and actually you have already been addressed to some extent, these questions, is how we can go in from reaction, from understanding the problem and from reacting to the problem to prevention. So this is one question that has been asked by Mo Blecker, but it is also related to other questions that go into that direction from different angles, including whether how dealing and recognizing past violations can prevent future atrocities. So is anybody would like to take the floor on this, on how to really enhance the prevention of future problems rather than reacting to current ones? Any of the panelists? Mariana.
I mean, from our point of view, looking at it from a field perspective, it would be, I think, really helpful for the reporting that's done from the field missions, from human rights NGOs, from a range of actors that are on the ground to use a kind of mass atrocity prevention lens or a hate prism to action when they do reporting on human rights violations that are along that continuum or path towards genocide. And in some countries it's done, but in many it's not. I'm thinking, for instance, of countries like South Sudan, where a lot of the violence is ethnically motivated and based on divisions. And the Security Council reports, for instance, you know, the UN mission there every 3 months provides reports to the Security Council. They, you know, have a special section on conflict-related sexual violence and all the different types of incidents and killings that are taking place. But there is no filter that gives us a sort of understanding as to the motivation and the different cleavages that are involved. And I think connecting these two would make it really much more clear what kind of interventions are necessary, where there is scope for reducing tolerance or having some kind of activities that maybe address the motivations, where there is no scope, etc. And perhaps also perhaps because Sylvia, you are chairing, and There is also an aspect that relates to the ICC and to the international criminal law as well. I think that in many cases, this lack of a lens on looking at the motivation behind the violence also means that the distribution of justice, perhaps by international bodies, isn't perceived as just on the ground. And I'm thinking of the case of Ituri in Eastern DRC, Eastern Democratic Republic of Congo, where, for instance, we had a number of cases that are some still before the international courts. And these aren't necessarily selected on the basis of the cleavages between the different groups on the ground. So in fact, they tend to favor one particular group over another. Maybe it's but just coincidence, but perhaps in one strategy, if one wants to see a deterrent effect of international criminal justice, there needs to be some situation analysis in respect of the fault lines between the different groups that are fighting, to make sure that the distribution of justice is perceived to be fair from their point of view, and it isn't favoring one group over another. If we just look at the crimes that are being committed, then we may not see what local people see in terms of these motivations, and that kind of itself fuel more violence. In fact, this was the first blog we wrote as Rights for Peace, which also motivated the establishment of Rights for Peace, was looking at lessons learned from renewed violence in Ituri, and how perhaps the strategy in relation to the cases in Eastern DRC didn't favor a deterrent effect.
Thank you, Mariana. There are other questions, and unless any of the other panelists would like to speak on this issue. Yes, Carl.
I want to pick up on what Mariana, you just said about Ituri. One of the things that I was struck by with regard to the case of the 46 Batwa who were killed recently was that the media reports of that killing did not describe the ethnicity of the victims, at least the ones that I was seeing in international media. And I was really struck by that, that there was a kind of blankness, a blindness to that aspect, that they all belong to an extremely marginalized community such as the Batwa. So that's just one thing I wanted to say in terms of, and following up on what Mariana, you said. In terms of prevention more broadly, I think that one of the things the international community, and I include NGOs, civil society here, we need to get better at understanding the full range of the early warning indicators. So for instance, our focus on issues concerning Rohingya in Myanmar has long been to do with statelessness, the successive reduction and elimination of their citizenship rights over the decades. And we worked very actively, for instance, in UNHCR's excellent I Belong campaign, combating statelessness and so on. And we accompanied Rohingya participants, assisted them in presenting before various UN bodies and so on. But sadly, although of course we took the situation extremely seriously and there have been bouts of violence along the way, I have to say, in hindsight, honestly, when I look back and think about our work on statelessness maybe 10 years ago with the Rohingya, I don't think we could have imagined, I did not imagine that we were going to see that huge push to essentially eradicate, force out the whole community out of that country. And so I think we also need to do some soul searching ourselves and think about how we could have seen that successive removal of citizenship rights from the Rohingya community in Myanmar as an early warning indicator. And I'm thinking, 10 years ago, 15 years ago or so, in order to prepare better and in order to try and prevent that from happening again. That's one example where I think we need to do better. And then also there are other indicators that are worth reflecting on. I saw, for instance, there were questions about Ethiopia in the Q&A. One issue that we are concerned about is internet shutdowns and how internet shutdowns lead to a silencing of civil society. Now, I understand that the Ethiopian government has explained internet shutdowns as a way of preventing violence, as a way of preventing hate speech and so on, cyber hate. But for us, working with civil society activists, it makes it particularly difficult to be in contact with our counterparts in country and to gather information and get a complete picture of what's going on. So rather, we take internet shutdowns as a risk factor that something is happening on the ground. So anyway, just to a few reflections. I'm sorry that they're a little scattered, but simply to try and broaden our approach of what we're seeing as signals needing to trigger a preventive approach, and then to learn properly from when we have received those signals before.
Thank you very much. I'm afraid we are getting into the end of our panel today. I would like to know if on these issues, is any of you of the esteemed panelists would like to add anything to what has been said now? Mariana.
I would just like to make a small comment and thought, really, and just responding to what Carl was saying about soul searching. I think what is interesting about the need to be ahead of the game and to think forward about the violations that are taking place and the different groups maybe that are being discriminated is perhaps one also needs to look at our own biases. I think sometimes, when it's difficult to predict, as Carl said, we don't know what will then ensue and what the steps will be. And of course, it's difficult to prevent something that we don't know is going to happen. So I think one needs to be attentive to every different case and take each case seriously when minority groups, when other individuals raise their issues. It's important that we observe our own biases towards groups that are discriminated against. I think that's just it's an important point. It's often very easy to dismiss groups because they're not yet the big news. So we just think, oh, who are this new group that has now emerged and that is raising issues? So I think every group needs to be taken seriously.
Thank you very much, Mariana. I think Michael wanted to. Yes, Michael, you have the floor.
Just very briefly, because in the chat box, there's one excellent question on the role of armed non-state actors, especially in the context of the elimination of hate speech. And then this person, Havre, is saying there are many armed non-state actors controlling a big portion of territory and millions of people. And absolutely spot on. It's basically these also non-state actors, especially once they control or exercise effective control over territory and or population, that they also have specific human rights responsibilities. That's not only under international humanitarian law, but also under international human rights law. And there's now really a host of UN reports by special rapporteurs, by commissions of inquiry, fact-finding missions, by the Office of the High Commissioner for Human Rights, which is really developing this gradually and then giving teeth to this, because the standard approach is basically states are the only duty bearers. And I think this is an important also change in enlarging the number of duty bearers to precisely better protect the rights holders. it doesn't matter if basically the state or a non-state actor is basically violating or abusing your human rights. You should be equally protected. And I think also in the context of genocide and atrocity crime prevention and hate speech, we should really bear this acutely in mind.
Thank you very much for picking this up, which was indeed a very important issue to tackle, and that goes, and I may now give my final words now, because we need to close the segment, the panel. But indeed, I think throughout this hour and a half, it has been stressed very much that effective action in terms of prevention of hate speech and prevention of genocide and massive atrocities does require collaboration, coordination of all relevant actors. And I thank you, the panelists, for giving an overview of the existing mechanisms, the existing strategies and plans of actions that have been already developed in various fora, in particular, of course, the United Nations, but also in regional organizations, but also for stressing that this should be addressed by all relevant actors. And indeed, in terms of taking action, it's not only states, but of course also non-state actors are duty bearers, but also all other relevant actors can take a negative and positive impact in preventing hate speech. And of course, the religious leaders their role was underlined, but also of other actors. Now, I thank you also for addressing the gaps, the challenges and the problems, including the need to fill certain gaps, like stressing, and you have stressed very much the need to stress the motivation, the bias when you're dealing with reporting mechanisms, and also the need to maybe clarify, I think it has come out from your statement that the need to clarify what is hate speech and is important, and that the unified framework that is being provided by the UN strategy is very helpful, even if it is not a binding definition and it covers lawful and unlawful acts. It is important to foster understanding of what is hate speech and avoid these problems of vague regulations or under-targeting or over-targeting, as you have said. So this is extremely important, and of course the discussion will continue. We are witnessing a huge problem of hate speech at global level, and I want to here announce that GAAMAC will continue this conversation. I will be hosting a global conversation on strengthening national efforts to address hate speech, discrimination, and prevent incitement during our 4th global meeting, GAAMAC 4, which will take place this year in November. But for those who would like to continue the conversation with Rights for Peace and perhaps organize a roundtable discussion with a wider group, I would advise you to contact Rights for Peace via their website. And of course, also you can contact GAAMAC via our website. So I would like now to thank you all the panelists. I would like to thank the participants for their interest, their engagement, and their wonderful questions. And I wish you a good rest of the day. All take care. Thank you very much.